In the digital age, protecting personal information is a global challenge. China, with its vast and rapidly growing digital ecosystem, offers a critical case study on how a major nation balances individual rights, technological innovation, and state imperatives. This research introduces a comparative study of China's approach, specifically analyzing its laws against universal human rights principles like those in the Universal Declaration of Human Rights, UDHR. China's digital transformation has been exceptionally fast, fueled by widespread internet use and state-led strategies. This rapid growth created urgent challenges in data security, privacy, and controlling the power of large tech platforms. In response, China developed a core legal framework, the Cybersecurity Law, the Data Security Law, Personal Information, and the Landmarks Protection Law, or PIPL. These laws aim to create a secure and orderly digital space that supports both economics, growth, and social governance. This study is guided by three key questions. First, how do China's constitutional principles and data laws conceptually compare to the rights to privacy and non-interference in the UDHR? Second, what are the real-world cases in China that highlights tensions or alleged violations in personal information protection? And third, to what extent does China's current framework successfully balancing individual rights with public and national security interests? And where do challenges remain? To answer these questions, the study has three objectives: to conduct a comparative legal analysis, to identify and document specific cases of enforcement challenges, and to analyze these cases through the dual lenses of Chinese law and UDHR principles. The methodology is qualitative, combining documentary analysis of legal texts, in-depth case study research on issues like mandatory app registrations, and a comprehensive review of existing academic and expert literature. The study acknowledges limitations, such as restricted access to official enforcement data and the evolving policy environment. Despite this, its significance is threefold. It contributes academically to the study of digital rights in non-Western contexts, offers policy-relevant insights for improving governance, and provides a structured basis for a more nuanced global dialogue on digital rights.
China's approach to personal information protection is built upon a structured legal framework designed to govern data use in the digital era. At the constitutional level, privacy protection is reflected through provisions safeguarding personal dignity and the privacy of communications. Although these protections are broad, they establish the legal foundation for more specific digital governance laws. National security plays a central role in shaping China's data governance philosophy. Personal information protection is not treated solely as an individual right, but as part of a broader framework balancing public order, social stability, and technological development. The Cybersecurity Law, enacted in 2017, marked China's first comprehensive effort to regulate online activities. It places obligations on network operators to protect user data, enforce real name registration, and cooperate with government supervision. Building upon this foundation, the Data Security Law introduced a data classification system based on national importance and risk levels. It extends regulation beyond personal data to include industrial, corporate, and state data, while emphasizing national security and control over cross-border data transfers. The Personal Information Protection Law, introduced in 2021, represents a milestone in strengthening individual data rights. It establishes principles such as informed consent, purpose limitation, and data minimization, while granting individuals rights to access, correct, and delete their personal information. However, these rights coexist with strong state oversight mechanisms. Together, These laws form an integrated governance system that reflects China's effort to balance individual privacy, economic innovation, and national security in the digital age. In the digital age, technology has transformed how people live, work, and communicate. In China, online platforms, mobile applications, and smart devices have become part of everyday life. Behind this convenience, massive amounts of personal data are collected, stored, and analyzed. Every day, when personal information is misused or poorly protected, fundamental human rights may be placed at risk. The first case involves a smart door lock company in Jiangsu. It collected highly sensitive data, including home addresses and biometrics. Weak security allowed hackers to access it undetected. The court ruled such data directly affects personal safety. This shows data protection is not just about privacy, but also the right to home security under the Universal Declaration of Human Rights. The second case focuses on Michuan delivery riders and their experience under algorithmic management. The platform extensively used data and complex algorithms to control routes, delivery times, and penalties. As a result, riders faced unrealistic deadlines, constant GPS monitoring, and intense performance pressure. Many riders had very little control over their working pace or daily schedules. The court found that this lack of transparency and excessive use of data severely harmed workers' dignity and safety. This case clearly highlights how the misuse of data technology can threaten labor rights when proper accountability and oversight are missing. The third case concerns a Shanghai big data company that illegally collected and sold over 200 million personal records, including phone numbers, IDs, and residential addresses. The data was sold to businesses and criminal groups for profit. The court ruled that personal data is a legally protected right, not merely a commercial product. This case clearly shows how weak data governance can lead to fraud, harassment, and serious violations of privacy and personal security. These cases show that personal information protection is now a core human rights issue. In the digital age, courts play a crucial role in balancing technological development with individual dignity, privacy, and security. Without responsible data governance, digital progress may come at the cost of human rights.
Door lock data leakage case. Smart door lock devices collect highly sensitive personal information, such as access records, residential addresses, and user identities. In this case, the company failed to adopt adequate security measures, which resulted in the leakage of users' personal information. Under China's Personal Information Protection Law, personal data must be collected lawfully, minimally, and for a specific purpose. Access records and location data are classified as sensitive personal information and require enhanced protection. This case demonstrates the companies providing smart home technologies bear a high duty of care, especially when data is closely linked to personal safety and property security. The second case is the Michuan rider data labor case, which focuses on algorithmic control. Michuan manages its delivery riders mainly through algorithms that determine order allocation, delivery deadlines, performance evaluation, and income calculation. Although riders are often labeled as independent contractors, algorithmic systems exercise substantial control over their work. According to China's labor law and labor contract law, the existence of an employment relationship depends on actual control and subordination rather than contractual labels. In addition, the Personal Information Protection Law grants individuals the right to transparency and explanation in automated decision-making. This case highlights the legal challenge of protecting labor rights in the platform economy and regulating algorithmic management. The third case is the Shanghai Big Data Company illegal information trading case. In this case, a big data company illegally collected and sold large amounts of personal information without obtaining user consent. Such conduct violated the Personal Information Protection Law and the data security law. More importantly, under Article 253A of China's criminal law, serious infringement of citizens' personal information constitutes a criminal offense. This case clearly establishes that personal data is not a commodity that can be freely traded and that illegal data markets will face strict punishment. In conclusion, these three cases show how Chinese law addresses data leakage, algorithmic control, and illegal data trading. They emphasize the core principles of privacy protection, algorithmic accountability, and lawful data use. In the digital economy, technological development must operate within legal boundaries, and law remains a crucial safeguard to protect individual rights.
Chapter 5. Suggestions and Conclusions. Based on China's legislative framework, cybersecurity law, data security law, and PIPL, 3 representative judicial cases, and the core principles of the Universal Declaration of Human Rights (UDR). This chapter presents targeted suggestions and comprehensive conclusions. While substantial legislative progress has been made, gaps still remain between legal norms and practical enforcement, aligned with UDR's protection of human dignity and individual autonomy. Here are the key suggestions. Firstly, strengthening enforcement and accountability mechanisms. Intensify supervision for high-risk sectors like smart homes and finance. Unified law enforcement standards, with penalties reflecting both economic harm and UDR's emphasis on personal safety and dignity. Secondly, enhancing corporate data governance and compliance. Enterprises must adhere to the data minimization principle, establish encryption and access control systems, and empower personal information protection officers, upholding UDR's guarantee of personal information autonomy. Thirdly, improving transparency and user participation. Platforms should clarify algorithm logic like writer delivery rules, and safeguard users' rights to access, correct data, and appeal decisions, aligning with UDR's principles of fairness and remedy. Fourthly, regulating algorithmic management and protecting digital labor rights, ensuring human oversight of algorithmic decisions. Prohibit excessive surveillance and unreasonable performance targets, preventing technology from violating UDR's protection of labor dignity and safety. Fifthly, strengthening public awareness and digital rights education. Popularize data protection knowledge and legal remedies, enabling the public to exercise rights enshrined in UDR. Fostering a digital society that respects privacy and human dignity. In summary, China has laid a solid legislative foundation for personal information protection, closely aligned with UDR's objectives. Bridging the law-practice gap requires strict enforcement, corporate responsibility, and transparent data use. Personal information is not merely an economic resource but an extension of UDR. Guaranteed autonomy and dignity. Effective data governance ultimately balances protection, development, rights, and responsibilities.